You're watching KTN Prime. Thank you for staying with us. Let's bring you some breaking news from the Supreme Court that has been hearing that case touching on the retirement age of Supreme Court judges Kalpana Rawal and Philip Tunoi. And as we speak, Willie Mutunga, who is the Chief Justice of the Supreme Court, has just ruled that the orders from the Court of Appeal stand. In other words, Judges Kalpana Rawal and Philip Tunoi will retire at the age of 70 as opposed to 74. Remember, the two had gone to court to contest that decision to have them retire at the age of 70, saying they were sworn in before the promulgation of the new constitution. Chief Justice Willie Mutunga has just ruled that the orders of the Court of Appeal stand. He's also ruled that orders given by Njoki Ndungu have been vacated. In other words, in simpler terms for you, those orders have been thrown out. And Chief Justice Willie Mutunga, they are saying Kalpana Rawal and, of course, Philip Tunoi can appeal this particular ruling when a new Supreme Court bench is constituted. Breaking news at the bottom end of your screen, touching on the retirement age of Supreme Court judges Kalpana Rawal and Philip Tunoi. Let's bring in Elisha Ongeya, an advocate of the High Court. Elisha, this has been a very long ruling, 4 hours, so to speak. What does this all mean?
First, it was an important ruling for the Supreme Court for a number of reasons. There is no time in the history of this country that a court has found itself as conflicted as the Supreme Court has found itself today in my reading of our judicial history. And number two, this ruling comes at a critical time because it comes barely 2 days before the Honorable Willie Mutunga leaves his seat as Chief Justice from his own advanced retirement plan. And therefore, this was going to be a critical ruling in terms of transition management. So it's going to be definitive in terms of transition politics and transition management at the Supreme Court. So these were politics surrounding this ruling that rendered the ruling extremely significant. But more importantly, the division that this ruling attracted from judicial officers, and I'm not necessarily talking about the philosophical division, even just the political division. You could see the language by the various judges at some point in time becoming very intemperate, also attracted quite a bit of attention and will be a subject of debate for quite a time to come as people look at the significance, the relevance, and the new dimensions that should govern the workings of the Supreme Court of Kenya moving forward as one of the institutions that were expected to revolutionize the workings of the Constitution of Kenya 2010. So those are factors that I think render this ruling much more significant than the technical legal questions that the ruling was addressing.
Elisha, Chief Justice Willie Mutunga just said Kalpana Rawal and Philip Tunoi can appeal when a new Supreme Court bench is constituted. So basically, this is it.
Essentially, something funny is that substantively the appeal by Tunoi and the appeal by Rawal have not been determined on their merits. The court has withdrawn itself by a majority of 3-2 judges from entertaining that appeal. The judges have reasoned, the majority have reasoned that it's been such a scenario of conflicts of interest that the stature of the court would be extremely diminished if the court were to sit and hear this matter. So the appeal remains there hanging in abeyance, which cannot be heard by this court as currently constituted, which is why then if a new bench is instituted and they feel for academic reasons like appealing, then they would appeal. Because remember, he has said once the new court is constituted, that court would have been constituted without the two. So the court will be fully established without the two, and therefore even appealing would be purely for academic reasons. It will have no practical
Elisha, stay with me for a few minutes. I can see live pictures from the Supreme Court. Paul Mwite, a lawyer there, just addressing the Supreme Court. I'm hoping you can listen in just a little bit. Elisha, stay with me.
12 by the applicants. There is the issue of the application by Omutata. It is not clear to us what the applicant expects, or rather the applicants expect will happen within the 21 days, in respect of which we are asking for a stay. The reasons given for allowing Omutata's objection are, amongst others, that 4 of the judges of this court expressed themselves on the issue as to whether the age is 70 or 74, and would therefore not be perceived to be impartial. What are the applicants expecting will happen with regard to those 4 judges in the next 21 days? Finally, it is our submission that indeed, in the very unlikely event of the appeals succeeding before an impartial and neutral bench, whenever that might be in the future, the appeals will not be read ad nugatory, my Lord, your Ladyship, because damages will be an adequate remedy. If, in the unlikely event they succeed, that the retirement age is 74, they will simply be paid the balance of the term that they have not served. Lord, is already a finding. There is no proprietorship in public office. It doesn't have to be that a Mr. X must be the judge of the Supreme Court or Mrs. Y must be the Deputy Chief Justice. There is no proprietorship. So that public interest inclines towards what this court has done by a majority, open the doors that had been closed to the Judicial Service Commission by the ex parte orders on the 27th of May, so that the Judicial Service Commission can proceed expeditiously with the recruitment of the Chief Justice of the Republic of Kenya, Deputy Chief Justice of the Republic of Kenya, and a judge of the Supreme Court, so that we can have a Supreme Court fully constituted with a full complement of the 7 judges. That is what public interest demands. Let's not have any further delay of that whatsoever, as and when a neutral bench is constituted, wherever that might be, and in the unlikely event of this court holding that the retirement age is 74, not 70, then damages, in my submission, will be inadequate.
Those are live proceedings from the Supreme Court of Kenya currently going on. Lawyer Paul Mwite addressing the bench. You can still watch the live proceedings from the Supreme Court on KTN News, that is DSTV channel 274, Zuku channel 14, and GoTV channel 94. If you're interested in that particular ruling that is currently being given at the Supreme Court of Kenya. So let me just run you by what has just happened. Chief Justice William Mutunga has ruled that orders from the Court of Appeal stand, which essentially means Kalpana Rawal and Philip Tunoi will retire at the age of 70 as per the Constitution. He also ruled that orders given by Njoki Ndung'u have been, so to speak, thrown out, and he's asked Kalpana Rawal and Philip Tunoi to appeal when the new Supreme Court bench is constituted. And we have just spoken to Elisha Ongoya, an advocate of the High Court, trying to help us understand what has just happened. So you want to be part of that conversation, you can watch KTN News.